We'll get started. We were just talking about different short ways to do things on the keyboard. Of course, the Alt-Tab, I guess I don't do that much switch between windows. One of my favorites, though, is Control-Z. Have you guys done that one? You make a terrible error and you think you ruined things, and the back button won't work because it's not that type of a thing. Fixes some major, or prevents you having to do some major redos sometimes. Can get back content. I should probably teach it to my students that have 2-year-olds and 3-year-olds. I will just tell you right up front, the biggest problem that students have had with this is mixing up torts and criminal. And I don't know whether they just really don't get it or whether they're just doing that because it's convenient or something, but that's a major no-no. The problem is the facts are often, the on-the-ground facts may be the exact same thing. Sets of laws. That's been a major problem in the past. So one of our main goals or objectives this week is to differentiate between an intentional tort and a crime. Absolutely do not want anyone to leave this course without understanding the fact that you know, if you hire a private eye, they may end up finding a lot of the facts of the case that the police also found. I understand that. Let's say we're a plaintiff or defense attorney and we hired a private eye to investigate this alleged intentional tort. They're going to find a lot of the same facts that the police find, but there's a huge difference between the sets of laws and the procedures. Of course, one of the other problems is some of the defenses are the same. If you have a complete defense to a crime, it's probably going to be a defense to the related intentional tort. So that messes up our thinking. But what's our goal? What's the goal of a criminal charge? Looking at it from the prosecution point of view. Your voice kind of cut out. I wasn't able to really hear you. What's the goal of charging somebody with a crime? Jody, can you hear me now? Yes, a conviction, okay.
So that they can get prosecuted and get convicted?
Right, and what's the ultimate goal? What happens if they are convicted?
They'll go to prison.
Prison or fine, but it's punishment. Punishment on behalf of the public in general, right? The citizens. Hold on just a second here. Okay. Yeah, this is interesting because consent, self-defense, defense of others are defenses to crimes and torts. So that makes it difficult to remember we're not dealing with the same thing. So what is the goal of a civil lawsuit for an intentional tort?
They usually seek monetary damages.
Yep. Yep. What happened in? Does anybody know what happened in the lawsuit against O.J. Simpson by the families of the deceased people involved? The lawsuit. Were there damages assessed? In other words, was there a money judgment with damages? Answer, yes, there was. And I believe that some of them, I don't know if they were all paid, but some were paid as a result of a book deal, I believe. Yes, they won money damages. Intentional tort, transferred intent is really odd. And I'm not very good at drawing, but let's just say that Mr. A has it in for Mr. B. Oh, I'm going to go back to writing letters or using regular letters. And hurt him. Is that intentional? What do you think? It is intentional because it's still not negligence. He was striking out with the idea of hitting somebody, and he did hit somebody. He hit the wrong person, but that's called transferred intent. So you can't really call it negligence. It's treated in the tort law as intentional. It's an intentional tort to the person. And then there's torts against property. And here's your live classroom word is intent. So I realize we're moving along pretty fast. But a lot of this, frankly, is just going to be reading through and making sure that you put these lists of elements in your notes. Each element must be proven unless one element is stated in the alternative. I believe that the intentional battery of somebody, there may be an alternative in the sense that either intends to hit the person that he hit, or he intends to hit somebody else and mistakenly hits the victim. So that would be kind of an alternative. Some other torts that we're not dealing with are a little more complicated. But unless otherwise instructed in the text and the lecture notes, lesson notes, each element must be proven more likely than not. Which is called a preponderance. Who knows what the if the same acts are treated as a crime by the police and the prosecutor, who knows what their level of proof has to be?
Proved by reasonable doubt. Reasonable, yeah,
right.
reasonable.
Right, absolutely. Tort, intent, intentional. And then a criminal violation. Trial. So basically, and I had a client complain, well, why didn't I get my driver's license back? I said, well, that was a civil case in our state. Well, then why did I win the criminal trial? Because that's a criminal trial in our state. So there was a reasonable doubt that you were not driving the vehicle. That was not it was not an assault or battery. But I'm just bringing this up as a real life example. But the civil part of it, the state could just prove that more likely than not he had driven. And because he denied being the driver, but more likely than not he was the driver rather than somebody else. But there was a reasonable doubt, so we won the criminal trial. He may not have been the driver. Not really, not proven beyond a reasonable doubt. Reasonable doubt is a very high standard. Preponderance is not. So it's easy for somebody to lose on a preponderance and still win on reasonable doubt. That's not an oddity. The difference is the type of legal action and the consequences, not necessarily the conduct. That's the difference. The written assignment is about Mrs. Larson and Tommy against Mr. Larson. One of the problems here, I'm not going to have you, I don't think we're necessarily going to trust the state statutes. Since you will find criminal ones, okay? I'm going to make that an extra. I don't know if it says that. Does it say that in the assignment? It says using your state statutes. Yeah, see, I don't agree with that. If you do, you're going to be wrong. What happened in the past is that most state statutes just give a statute of limitations. Any questions about that? Most intentional torts are common law in most states. Well, for instance, in Minnesota, there is no thing called criminal battery. It's all just called assault, whether they make contact or not. But if you sue somebody for battery, you would still call it battery, I believe. It doesn't happen that often that people are sued for intentional acts, and we kind of discussed that early in the course, but who remembers? Why doesn't it come up every day in the law office? Assume you're suing somebody who is not a famous celebrity or somebody who's wealthy. Or somebody who sort of represents a corporation or something. Where's the money going to come from if you get a judgment? Let's say I got a judgment against somebody who occasionally gets a job for cash, somebody who occasionally scraps rusted metal. Say, well, sometimes he clears 60, 80 bucks, but you don't know when he's going to clear it, and you'd have to have the sheriff over there to serve an execution of judgment on him just at the time when they paid him off for some of his scrap metal dealing, right? Or you could wait until he gets one of those part-time jobs where he works for cash and then garnish his employer at the right time. Then you get another 60 bucks. It's kind of a losing proposition, isn't it? You know, you have a $60,000 judgment against somebody, but it's never paid. What's the use of that? You're only going to get pretty much whatever the probation department imposes as restitution in the criminal charge, if anything. Maybe you should have called the police and just asked for restitution. True, you won't get probably mental distress and some of those other things, but you may get something if you were physically injured. And like I say, if you ever have somebody physically use battery, it'd be nice if it was a rich person that you could make them pay. My suggestion, though, is you can look at state statutes, but you won't normally find the answers. Use the text and lesson content. No, use the text and lesson content. I can try to find case law, but it's just not going to really. Case law, it's hard to find case law that gives you the big picture. Never a case that's been until something goes up on appeal, it isn't the law for anybody else. Yeah, if correct, a civil case for intentional injury to somebody would be a intentional tort. Yes, a civil case. Yes. Of course, new cases may define torts, but they're harder to research. My advice is to trust the lesson content and the text. And then supplement with state case law after you have the basics. In other words, as time allows. I would call this extra work. And I will display what I mean. Okay, we go to the written assignment, and yeah, it tells us to use statutes, but I just don't think you're going to get everything you need in statutes. I would tend to go to the module 3 intentional torts, then go to lesson content. Then use these. These are elements right here. Act by defendant, intent to cause harmful or offensive touching. Can't really highlight it, can I? Harmful or offensive touching and causation. Each of these bullet points is a element, okay? And then they list the defenses, and here's torts against the property, and each of these bullet points has the basic elements. So if you prove some elements but not all, normally you're going to lose if you are the plaintiff. If you're the defendant and one of the elements is missing, normally the defense wins. And it has the defenses here. The defense would have to prove the defenses. The other possibility, I don't know, can you see the text? Or do I have to go out and share again? Okay. And I would look at chapter 7 and 8. Basically, I would use this as an expansion of what you learn in the lesson content. The other thing is, I can show you how to get to the restatement of torts. And again, you're going to say, well, that's not really necessarily the same as state law. I understand that. But if you get to restatement, it's going to give you the basics you need to know now. And of course, you can always supplement that later on with case law from your home state. And here's some case law from Florida. But I think you're going to find that the case law is not going to really give you the basics. It's going to give you some point of law. And here's assault. apprehension basically means they know that a battery is about to happen. It may not happen, but they believe that it is. Apprehension. I noticed that they didn't call it fear. Some states would call it fear, but basically they think that that an unlawful touching is about to happen. It doesn't happen. If it does, then it's called battery. False imprisonment is pretty much like it sounds, but it's not technically in a prison. It could be in a closet or something in somebody's house. Confinement means that somebody cannot get out. And this case deals with false imprisonment, intentional infliction of emotional distress. And of course, you do want to go to torts to property because that'll use the terminology in the assignment, which is trespass to chattels. Not every state is going to use that, so that's another one where trusting entirely to state statutes might create problems for you. And I would just keep going through the text after you exhaust. You feel like the lesson content does not explain itself, and it doesn't explain itself thoroughly, then I would go to chapter 7 and 8 and fill in the gaps in your knowledge and use those. Use this. That would be what I would do in your place, rather than trust the state statutes. Okay, I will. We talked about elements and somewhat defenses. I didn't really talk about immunities, though. And I'll find the restatements for you. Okay, can you guys see the Lexis Advanced screen? Okay. We're not going to use state this time. We're going to use sources. Let's see, I don't, do I really want to do that? Oh, content. No, I'm not sure if this is in codes or not. I'm going to type it up here, restatement of torts. We're going to look at restatement of the law torts second. Can you guys see what I did? Because this is what's referred to in the textbook. They have third up here in drafts, but I don't want to see drafts. I want to get to the official torts, a restatement of the law torts second. Now, does it make sense? I'm going to type false imprisonment and see if it finds it for me within this source. And I'm going to take the second choice, false, because that looks basic. And you're going to say, well, this is very similar to what the text already has. Correct. But the text will not always be with you, and you may have a book version or a electronic version of Restatement of Torts that's used. I noticed that the Supreme Court of Minnesota uses restatements like Restatement of Torts, Restatement of Contracts, and so on. So I respect them because my state Supreme Court does. And then, of course, there are cross-references here to other sources. So these are where there's no definite case law in your state, using restatement would help a lot. Or where the case law is very hard to find, at least you've got something to go on. Yeah. And of course, within Restatement of Torts, you can go to back to table of contents, full table of contents, and you can do another search. You could say, excuse me, I didn't mean to do that, did I? You could do another search within there, and you could say battery. I'll try battery defenses, which may not work. Okay. Okay, that worked. Worked pretty well. Now I will try, as long as I'm here in Lexis, I will try a state. What state would you like me to try? Okay, we'll try Minnesota. Go to a state, Minnesota. And we'll do Minnesota state cases combined. This might be too big, but I'm going to just do Supreme Court cases. Still probably too big, but I'm going to try false imprisonment. It'll probably give me way too much. And I'm going to sort it by newest to oldest, so I get a newest case available. See, and this didn't work because then it ended up with criminal cases, so we don't want them. And okay, I'm going to see if I can narrow it by torts. And this one is kind of a silly electronic thing. It's in a dissent, and but the case is not basically about false imprisonment, so not very usable. This one looks, let's see, this is not very usable. Not very usable. So it's kind of like a hunt and peck job here, trying to find things. Okay, here's one that really is about false imprisonment. it's an odd one. Somebody claiming a doctor did false imprisonment. So this one might actually define false imprisonment in this state. But look, crimes against person, false imprisonment. But what does this say? Actions shall be commenced within 2 years. That's not really helpful. That's not defining the tort. That's just saying how fast you have to bring the lawsuit. So this kind of proves my point, doesn't it? That it's going to be hard to find what you really want in state law. I would tend to go back to, if I were working in a law office, I would tend to use a continuing legal education material from the correct state, and that would have the law of that state up to date. But you have to, because the people making the continuing education for that state would have been through dozens and dozens of cases. The other thing I would do is I would use a secondary source specifically for that state. So for Minnesota, I would probably use one of the, let's see if it has secondary sources, secondary materials, practice guides. I would use Donnell Digest probably for Minnesota, which is not available in other states. That would tell you more about the Minnesota tort law than a lot of other stuff. I'll look in Donnell Digest for tort of false imprisonment and see if it gives me anything. Okay. False imprisonment, let's see. I would look in the torts article. So this is kind of where I'd be looking. Just to see if there's something in there for Minnesota. Infliction of emotional mental distress is in there. So this would tell you whether negligent infliction of emotional distress is a tort in Minnesota. Okay? But it's a long way around. Who else has the state? I can find a secondary source for you within your state if you'd wish me to. The smallest population states often don't have a secondary source there, although they are available from your state law library often. But I will certainly look one up for you in Lexis if available. When you do IRAC, you do issue, rule, application, and conclusion. An issue might be stated fairly simply. These facts show false imprisonment as a tort. And the rule would be the elements from the text or lesson content, okay? And then the application analysis would be apply it to the case, okay? And the conclusion would just be simple. What was the boy's name in the hypothetical? Mr. Johnson is alleged to have falsely imprisoned Tommy. Yeah, Tommy. Thanks. Would be the conclusion. Now, I usually don't do those in essay format. I do IRAC using a table. You guys ever done tables? And people say, well, yeah, but then it won't be the correct page numbers or whatever if I do all that. I don't worry about page numbers. You don't have to worry about page numbers in my class. You can do extra page numbers or fewer. Do you see where it says table up in the upper left, or insert? You do insert and then you do a table. And then you can either do it this way, or you can just do insert table and tell it how many columns. And I probably want 4, but I want a number of different rows. Let's see, how many columns do I really need though? No, that's not really what I want, is it? So let's do insert table. What do I want here? Oh boy, how did I used to do those? Okay, issue would be was there confinement? And we had used the torts text, right? So use Richard Jeffries' text, get the correct page number. False imprisonment, 158, right? Application would be facts showing confinement. Conclusion, yes. Tommy was confined. The other way you could do it, you could simplify it down. You could do elements. You could do rule source on element application. This might be better. So element would be act, intent, confinement, and causation. You don't have to. It's just more fun. These are lawyer tested. I brought them to lawyers. So there's 4 elements. Which are also the issues. And the rule source, we would need to use the same page for all of them, page 158. Supra page 158, which just means, well, basically the all the other citations would be the same. Okay. Application. You would have to tell what Mr. Johnson did. Obviously, don't type here what I'm typing. What did he do? Did he put Tommy in the basement, or did he just hold on to him? What did he do? Locked him in a room, or what did he do? And was this confinement? Tell your opinion. Is intent proven? And did this actually cause Tommy to lose his freedom? For a period of time. It's interesting they didn't put damages in there, did they? Oh no, they added the damages at the end. Okay, so okay. Actually, that's page 159, isn't it? Can we use general damages? Any questions about doing this? It's not required, but it's fun. I want to make it bigger if I can here. Of course, then when I made it bigger, I created a kind of a problem, didn't I? Okay. There we go. It's more fun, and it is lawyer approved. In other words, I have field tested these with lawyers, and they like them. Why do lawyers like them? Because if they want to know where you got it. So we've answered the question, What are you talking about, or what did you find? Lawyers want to know, what did you find? And we answered that question fairly clearly, didn't we? And then where, and what you think, or your application, of course, what you think, and your conclusion. So these two, the last two would be what you think, the last two columns. This would be thinking, and this would be thinking, wouldn't it? The conclusion. So what'd you find, where, and your thinking. So it's easy for the lawyer to go through it and say, well, what is it my paralegal is saying? I don't get it. It's going on, and I still don't get it. I'm in a hurry. And you pretty much say, well, okay, this, maybe you put a restatement in instead of a textbook, but you basically made it skimmable. And the judge's notes would look somewhat like that. They may not be in table format, but the judge, as they're listening, deciding whether the jury is going to be allowed to deliberate on it, or whether it's going to be dismissed. The judge is staring at those elements in his notes and wondering whether the facts justify allowing the jury to hear, not only to hear the case, but to deliberate on it and make the decision, or whether it should be removed from the jury and dismissed. Is there evidence on each of those elements or not? And so the fun way of doing it as a table actually works pretty well for lawyers because it's skimmable and it's easier to create a visual aid. Okay, yeah, it is simply IRAC, yes. Yeah, we're trying to simplify IRAC to the extent that we can. We want to make it more skimmable, more of a visual aid. And I wouldn't give it to you if I had not talked to lawyers who like to see that. It makes sense to them because it's analytical. It's not a beautiful essay, but it's bare bones analysis, and that just helps. You can come to the role play tomorrow night. It's actually not going to be necessarily a role play, but we're going to talk about it'll be about unwanted phone calls. I just got a phone call from somebody claiming to be a phone company, and I know they're not trying to sell phone services in our area, that company. So I said, if you give me your personal email, I'll send you an invitation to a free seminar on how to avoid unwanted phone calls. And the guy hung up on me for some reason. I also got a hang up from somebody trying to sell me a car warranty too. So anyway, come if you can. It'll probably be 30 minutes to 45 minutes tomorrow night. And the discussion answer posed to at least 2 other classmates. Basically, we're trying to work on the dog bite case. Governmental immunity, we're not really dealing with that, but study it because it will help you to know that. Some states don't have as much, or do have full immunity, sweeping immunity, but with legislative exceptions. And there are lawyers in some states, and I won't mention the states, that have gone out there and photographed every municipal error likely to cause injury because of what's called a notice requirement in their state statutes. The state can't, or the municipality like the city can't be sued unless they have notice. So then they send them all these photos to give them notice that kids skateboarding are liable to be injured on the skateboard park. The sidewalk next to the park where obviously people are going to skateboard has all these big problems with it, could send a kid out into the street. And of course the cities are highly indignant when they get these notices from attorney, but the attorneys are doing this before anybody's been injured, some of them. So it's very interesting, but it's not really in the assignment, but I think it may be in a later exam like next week. So I would probably study immunity in your readings. Maybe I should put that on the recording. The reason I showed them is because it's easier to check your work and see if you really covered the things. Have I covered it? I mean, the biggest question I would have as a student is, did I cover the essentials? Tables force you to do that. And create and need visual aid. Especially where you have one of the columns pushes you for each element. You have a cited source. And then an application. And then a conclusion. You know, so you say, well, I just cannot seem to remember that I'm supposed to do a cited source for everything. It's kind of hard not to when you do the table. It's sort of like you can either check that off or you can't, you know. You can take you about 1 minute to see if you fulfilled it. So that's the fun of it. And the other fun of it is just that you created a visual aid that is also a study aid. And they're kind of fun to do. I don't know. It's an analysis table. And within, I disagree with you and say, well, I don't quite get your conclusion and your application seems flawed, but I really appreciate the way you organized that for me. So they will give you a thank you for doing something that they somewhat disagree with. Thanks for making it all plain. I see where I didn't really tell you, I really didn't explain this element very well. And your source, I don't like that source. So therefore this and this didn't work. But they can tell where you went wrong, and they're still happy with the fact that you organized it so well. And I've talked to lawyers about that too, and they say, yeah, if they can get things organized for me, even if I disagree, it still works.